You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 80, Invalidating Someone Else's Patent, part 4, Covered Business Method Reviews. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. I've talked about 3 ways to invalidate someone else's patent at the Patent Office: ex-parte reexaminations, inter-party reviews, and post-grant reviews. The next one is very specific and actually is being phased out on September 15th, 2020. And it's a special procedure specifically for invalidating patents related to financial products and services. So if your invention is totally unrelated to a financial product or service, you can probably skip this one. But it's a pretty short episode anyways, and you may as well listen to my voice, and you can put this on if you're trying to fall asleep, and you need something that's sleep-inducing. Now, technically, the challenge can only be related to a patent involving a method or a corresponding apparatus for performing data processing or other operations used in the practice, administration, or management of a financial product or service. So those are the actual words of what's allowed. You can raise any ground of invalidation, so novelty, obviousness, subject matter, meaning it's just an algorithm or mathematical formula. The standard that the Patent Office is going to use to get past the petition phase is whether it's more likely than not at least one claim is unpatentable. Also, and this is a little different, the person who can bring the challenge actually has to have been sued. So if you just don't like someone else's patent, you can't just use this procedure. You actually have to have been sued, and then you could use this procedure. So it's really limited as to who this would really apply to. You also have to wait until 9 months to petition for this, or you can use what I talked about in the last episode, which is a post-grant review. Now, you can always use a post-grant review or inter-parties review or ex-parte reexamination, even if you want to invalidate someone's business method patent. So this procedure is probably best if 9 months have already passed, so you can't use the post-grant review, and you're thinking you might want to invalidate the patent using inter-parties review, but you want to bring up things that aren't patents or printed publications, such as public use or something like that, or you want to invalidate the patent because the patent is related to some kind of algorithm, which often might be the case here because we're talking about financial services. And that's a subject matter issue and not related to novelty or obviousness. So why did they even have a special category for business method patents if there are other procedures? The Patent Office was concerned that there's a lot of litigation in the court system of business method patents, and business method patents have been real targets for patentability because there's a question on whether they should even be allowed at all. So instead of clogging up the court system, Congress wanted to create a way to invalidate patents in the Patent Office and not the court system. So it made an easier way to challenge business method patents without going through the courts. So if you get sued by someone in court for infringing a business method patent, instead of having the court decide the patent, whether it's valid or not, the person that gets sued can file a petition with the Patent Office to invalidate the patent using the covered business method review, and that puts a hold on the court proceedings until it's resolved whether the patent is valid. This program is set to expire in 2020, but it's possible it could be renewed later. It's a pretty narrow type of situation that this would be used, but now you know, and knowing's half the battle. That's a little reference to those of you who were kids in the 80s. If you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, contact me directly through my website at diamondpatentlaw.com. That's D-I-A-M-E-N-T, patentlaw.com, or email me at adam@diamondpatentlaw.com, or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.